Just in time for back to school, we have a California case law update. A lot has happened in the courts during the summer, so hold on tight and let's get started. The first decision I want to talk about is an important product liability design defect decision called Ortiz versus Daimler truck. So in this case, the plaintiff's mother was sitting at an intersection at a red light and was rear-ended by a truck manufactured by Daimler and driven at over 55 miles an hour at the collision. Unfortunately, the plaintiff's mom died in this collision. Plaintiffs filed suit against the driver of the truck, the owner of the truck, but also against Daimler for a product liability design defect. And the theory of the defect was that Daimler offered a collision avoidance system as an upcharge option on these trucks, but didn't include it as a standard feature. And so the owner of the truck didn't want to incur the cost and didn't pay to have that option installed on the truck. Daimler then moved for summary judgment, saying that even if there was a design defect, which they denied, there was no way that the plaintiff could prove proximate causation here. And the trial court thought that was a good enough argument to grant the motion. However, the Court of Appeal reversed and sent that back down, saying that the evidence here showed that had the crash avoidance system been installed in the truck, the collision likely would have been avoided. So the court said that because proximate cause is generally a question of fact for the jury and can't be decided as a matter of law, a reasonable juror could conclude that the omission of a safety feature that was designed to avoid this exact type of collision was in fact a design defect and was a proximate cause, if not the only proximate cause of the crash. And so the case got returned to the trial court